Magic 100. Welcome everyone. My name is Mark Leckington. I am honored to be here today as the Vice President of Affordable Housing Professionals of New Jersey. I'm filling in for the large shoes of Ed Schmier, our president, who couldn't be with us today. We have a great session lined up, and our moderator today is Samantha Hennessy, and I'm going to turn it right over to her so we can get started. Samantha.
Thanks, Mark. Welcome, everybody. This is an exciting session that we have for you all, hosted by the Affordable Housing Professionals of New Jersey. Myself, I'm a board member along with Mark Leckington. And we received a lot of comments from folks from some of our other sessions. And we're trying to progress through everything since the law changed last March. And coming up this June, we all know that our fair share plans have to be in from our municipalities. So this specific session discussing the proposed 599 regulations. We are excited to have Keith Henderson and Heather Mahaley from the DCA. And I will let them introduce themselves, but just a plug for Affordable Housing Professionals. We are an organization of professionals in the affordable housing industry that are really promoting affordable housing services and rules. And it's a very important time for us as we see this great law that's been put out, but now there's a lot of work to do, and all of you advocates and professionals, coming together to try to make this a successful integration. So I'll turn it over to Keith to introduce himself.
Thanks, Samantha. My name is Keith Henderson. I'm the Director of Local Planning Services. We're a planning office in the Department of Community Affairs, and we oversee a variety of planning-oriented projects helping municipalities with some of their land use issues, as well as redevelopment issues and urban renewal entities. And within our purview is also implementation of the revisions to the Affordable Housing Act. Heather?
Hi, I'm Heather Mahaley. I am used to be of COAH and now back at DCA, working on the A4 regulations and interfacing with municipalities on this. Glad to be here.
So what we have for folks for this hour that you're with us, we are going to have a presentation by Keith and Heather, and then we are going to dive right into a Q&A. I have some questions that I'd like to ask Keith and Heather, and then we'd like to open it up to all our attendees. So I think, Keith, if you could take it away and start your presentation.
Okay. Is that working?
Yes.
Okay. Well, thank you, Samantha, and thanks to AHPNJ for sponsoring this discussion. So today we're going to be conducting an overview of new rules proposed by DCA to implement revisions to the various laws put in place by Public Law 2024, Chapter 2. The new law basically splits and delegates responsibilities between DCA and something that's in the Administrative Office of the Courts called the Affordable Housing Dispute Resolution Program. The new law splits and delegates some of the responsibilities, as I said, and we're really only going to be talking today about the rules that we have proposed here. I should actually go back. There's a link down there. Unfortunately, I don't think that it'll be clickable for folks that are out there, but that is a link to where the rule is proposed if anyone wants to try to write that down, or maybe we can just send it out to participants later. So, but anyway, in drafting the proposed rules, our focus is pretty much limited. That separation between DCA and the Affordable Housing Dispute Resolution Program is pretty clear in the statute, and so really, all we're doing is focusing on the monitoring provisions that were assigned to us, the review of some of the development fee ordinances and spending plans that are part of the new law. And so as we were drafting these rules, which were published on March 17th. The comment period ends on May 16th. When we were looking at it, we realized that quite a bit of what we're proposing is just holdover from the way things used to be done when it was under COAH's jurisdiction. There's a few things that are changed as a result of the new law, but not a whole lot. So in drafting the proposed rules, we tried our best to approach things from the if it isn't broken, don't fix it perspective. So basically going to just get right into what we are proposing. So in subchapter 1, this is just the basic intro and definitions. Most of the definitions are the same as what we had in the previous rules, except for the addition of the Affordable Housing Monitoring System and compliance certification issued by the court, and a few other revisions having to do with references to the Affordable Housing Dispute Resolution Program. Emergent opportunity has been added per the statutory requirement that DCA review those issues to help streamline municipal implementation options. And firm and binding obligation has been added to provide some additional guidance to municipalities in addressing those old 2008 amendments that required the expeditious expenditure of funds. In subchapter 2, we're providing the basics on trust fund establishment, along with eligible and ineligible expenditures. Trust funds, as was previously the case, include development fees, payments in lieu of construction, barrier-free escrows, recapture funds, and any remnant RCA funds. Qualified urban aid municipalities now are also permitted to collect and retain fees with only the approval of their ordinances and spending plan. We're currently working with the Administrative Office of the Courts to clarify some of the DCA responsibilities there. There's a distinction there between the affordable housing or dispute resolution program costs and direct court costs. So under the way the program has been devised, when I say the program, I'm referring to the Affordable Housing Dispute Resolution Program generally. There are costs that you can incur as part of your admin cap that we'll talk about in a minute. There's a distinction apparently made in the statute that is between costs that are associated with participating in the program, as opposed to challenge costs that are associated with municipalities that decide not to participate in the program and want to pursue challenges just through the standard court process. Let's see. The 20% admin cap remains in place from previous rules, and while the rule proposal references a percentage to be spent on affordable assistance and very low income households, we're considering specifying something a little bit more specific upon adoption, and your input on that is going to be appreciated. We'll come back to that a little bit later. Development fees in our subchapter 3 essentially just lays out the requirements for development fee collection and retention. Some of the terminology has been updated to reflect the new involvement of the Affordable Housing Dispute Resolution Program, but the basics remain pretty much unchanged. In our subchapter 4, we provide for the processes and procedures for municipalities seeking to take advantage of opportunities that didn't exist at the time they were going through compliance certification process. So the compliance certification process, for all intents and purposes, is what COAH used to do with regard to providing substantive certification. And so a municipality that chooses to go through that process with through the program, they can basically do it the way the program has set things up. Let's see. If they have an opportunity, so how can I say this? If they included projects in the plan that they've submitted to the program to get compliance certification, and then a couple years pass and some new opportunity comes up somewhere, and they call it a quote unquote emergent opportunity, and they want to take advantage of it, the municipality is permitted to include that in their plan, but we've got to review it and approve it first. And it's going to basically be just a matter of taking a look at it to see if it complies with the statutory requirements, but also making sure that the proposal doesn't have any kind of negative impacts on what was approved as part of the compliance certification issued by the Affordable Housing Dispute Resolution Program. So let's see, then in our subchapter 5, basically just discusses the new reporting requirements for both trust funds and project and unit completions. The annual deadline, as you know, is February 15th, and the proposed rule establishes that all reporting has to be done through our Affordable Housing Monitoring System portal. We realize that many municipalities did not stay current with unit reporting during the third round court takeover from COAH, and we'll do our best to help municipalities catch up on that. The housing type, owner occupied units, rental, range of affordability, bedrooms, all that is quite a big range of information that's required in the statute. And, so we know that it's going to be a little bit tough, but we will do what we can. It's a potentially daunting task, reporting requirements, but we'll work together to make sure we get it done. Let's see. So municipalities that don't comply with the rules, of course, have potential ramifications, may be subject to forfeiture of their funds, but we're also going to try to provide technical assistance to help municipalities overcome any issues that they come across or that we come across during the monitoring process to try to make sure that that doesn't have to happen. Let's see. Of course, the commit to expend within 4 years, that was part of what was called A500 back in 2008. It's been part of the law for that whole time, but we will continue to look into monitoring that. And again, we're going to offer technical assistance to municipalities as we uncover any issues like this to see if there's something that we can do to help encourage them to come up with an alternative plan or something that they can do to try to make sure that those funds are expended properly, right? And so I think with that, yep, I'm going to turn it over to Heather, and she's going to talk about MHLs and AAs.
Thanks, Keith. And I'll just point out to folks, if they have a question, they could put that question in the Q&A box, and we will either answer it, during this presentation, or we'll wait till the end and answer.
All right, can everybody see my screen?
Yes.
Okay. Great. I know everybody's on the edge of their seat waiting for the next thing that we're going to say. So, and Keith didn't really go into this in the enforcement part of it. And we, there's in the 599 regulations, there's a number of things that we monitor, we make sure that municipalities are doing them, and that we can actually take action against municipalities. The regulations give us that ability. So missing deadlines, the commit to expend, accurate monitoring, use of funds on unapproved activities, those kinds of things, and MHL or AA non-compliance. We can take action against the municipality on those things. So that's part of the enforcement section. MHLs, so municipal housing liaisons, every municipality that has affordable housing pursuant to the act has to have an MHL, and we have been reaching out to towns to get those folks into the system, to get them connected, and to be able to reach out to them. So I implore, if you have not if you have not appointed an MHL, or that MHL is not known to us, please do that. We get to them through the system. So that MHL is responsible for the coordination of all the affordable housing activities in the town. So a very important role for us. Their responsibilities include being the point of contact for the affordable housing actions within the municipality, doing the monitoring. So that MHL is kind of responsible for that. Overseeing the administrative agent. So they need to be aware of all the administrative agents working in the town, working on each project, making sure that each project has an administrative agent and listing those folks on their website. This is important for everybody to know who to contact if they're interested in a development in your town. Coordinating meetings, getting to, bringing the affordable housing component together as soon as you can in the process is going to be very important for that person to do. It just makes things easier. If you're mandating use of an AA, you need to connect the developer with that AA as soon as possible. They got to work together. And then providing operating manuals and ordinances to the administrative agent so that they know what they're doing. In order to approve an MHL, we're going to need to see the ordinance that established that position. So a lot of towns have already done this. They did it a long time ago. If they can find that ordinance, they don't have to do it again. And the resolution or the letter from the manager or the business administrator appointing the municipal employee to serve. It has to be a municipal employee. If the MHL is also going to be the AA, they'll have to meet the AA qualifications as well. Education, I'm going to get into this in a little bit, but the MHL has to do the education program and continuing education as well. Administrative agents. So every unit will need an administrative agent. And that administrative agent is there to ensure that UHAC is followed on all of those units that are in town. Specifically, all of these things are things that you've seen before. They are from old hack. So affirmative fair marketing, applications, income qualification, random selection, all of those good things that we all know everything about. Don't think there's anything new in here that you have not seen before. So such other duties as necessary. So it's just, providing annual reports. So if the administrative agent is going to be responsible for the monitoring, they will need to have access to AHPNJ. We request that the municipality advise us that they can have access to that. We don't just give it, but that will need to be done by February 15th of each year. So if you've got new projects that need to come into the system, or as is the case in most towns, old projects that have not been entered, that may be something for the administrative agent to do. The administrative agent needs to do a manual. A few new things that are in here, within 5 days of the results of an application, the administrative agent needs to contact the applicant as to the determination of their eligibility. The face-to-face or outreach, and maintaining a database of applicable households, just making sure that UHAC, randomization, and following those rules is done. The AA has legal authority to carry out their responsibilities, and they can grant an income waiver for a difficult to sell unit. Administrative agents. So we're going to be working with the AAs to get them approved. So there's a whole thing in there about we will be approving administrative agents. Whether a municipality has one AA for all of their units or several AAs for different projects, we'll need to have all of the AAs that are in a town approved. They'll need a certificate from the education program and a statement of intent to continue educational opportunities. Disclosure of any interest held by the AA, a template of your contract, and a sample operating manual. And we will evaluate and determine whether you are an approved AA, and then we'll continue to monitor you. This came also from Old Hack. there's a lot of, this is all the stuff that if you're changing AAs, reach out to the people who will want to contact you in the future, your owners and your landlords. And then just what you would normally see needing to change hands. Education program. And, again, building the plane as we fly it. This is because UHAC is new. Interim UHAC rules were adopted in December. Those are now being updated to the permanent rules. Some changes are being made. The education program had been established between Rutgers, AHPNJ, and COAH way back when, and it was a good program. It's still going on today. It's terrific. But as you might imagine, it will need to be updated because UHAC will, mandate changes to the curriculum there. But we are, we will be doing that. It has not been updated yet and won't be until we know what we're doing, what we're updating it to. So it, the overall goal is to teach everyone their role within the affordable housing process. The classes do, there's a charge for the classes, but municipality may pay for the employee through their trust fund. And this is just, all of this is, it's in the process of being refined and changed, but is not there yet. But will be soon. So that is the thrilling story of 599. Here's our website. Proposed rules are there. If you have any questions, concerns, need OMS access, whatever it is, there's our email address. Simone and I are here to answer your questions, take care of your issues, that kind of stuff. And, happy to do it, happy to do whatever we can to help you in this journey.
Thank you, Heather. So there are a couple questions in the Q&A, but I'll start with myself and just hearing you and Keith kind of go through your presentation. I think the question in my mind is, how different is this process than when COAH was established and the requirements of COAH, the reporting and the monitoring? Is it going to be similar? Because it sounds kind of similar.
Yeah, so COAH we had the CTM system. All of the information from the CTM system, which was used, people would put up their trust fund information in there. We have upgraded that system to now this OMS, Affordable Housing Monitoring System. Everything from the CTM was uploaded into the new system, and we're going to be adding some things to make it even a more robust experience, like being able to put spending plans in there and tracking your percentages and how close you are to those kinds of things. So, so it's going to be a better, I hope, user-friendly experience for the person inputting. But, and I will stop sharing my screen. Oh, I'm not, sorry. It very similar, I would imagine. Now, though, it is mandated by the law. So we will need to see those things in. And this year was a trial run. February 15th came and went. Some people got it in, some people didn't. We're now working with towns, especially with their trust fund information, to try to reconcile. We'll do that as much as we can, but at some point it will be a requirement, I'm imagining next year, that they get that information in by the 15th.
So in a nutshell, for a layman like myself, I think of it in my mind where, so a town now, whether they were following COAH before or not, all towns have to submit their housing plan and their spending plan. That gets approved, the number gets set in terms of how much affordable housing they have to do. And then once the towns do that, it's really then making sure that they have their ordinances in, making sure that they have their administrative agent lined up, making sure they have their municipal liaison, to then take that and then, really follow it through to get that affordable housing built and then monitored. That's kind of how I see it in a nutshell. I did write down, though, for folks who didn't hear that or do not know, the comment period to the 599 rules are due May 16th. So if folks have any comments to these rule proposals, to get them in before the deadline, I certainly printed everything out to go through it. But I will kind of go through any Q&As. I think we answered some of them, Heather, just through your presentation. So the first question we received: are affordable housing units required to undergo annual recertification to maintain compliance with regulations? If so, how is that recorded? I don't know if you or Keith can answer that question.
I'm guessing you mean by annual recertification, you're talking about the occupants of that unit. And if that is the case, then no, they do not have to be annually recertified, neither owners nor renters.
The second question, can the same person serve as an AA and the municipal housing liaison for the municipality?
Absolutely.
I think you answered
Yep.
that can be. That'll help. I think a lot of towns may opt for that.
Yep.
The next question: does the AA need to be approved by council resolution?
It does need to be, well, no, it does not have to be. It can be a letter from the business administrator. So it does not have to be a resolution. Usually that's what we see, but it's fine if just a letter.
Right. And then I guess you have to provide whatever background, education to qualify as an AA would be what you would have to submit.
Yeah, you have to have been through the education system. And this is a work in progress as well, because obviously, the education system, even if you have done it, because it's changing, there will need to be some updates that people go through. We have to figure out what that is, like re-upping your certification at some point. But yes, that education certificate from Rutgers will be required as well.
And right now is only Rutgers is the only place, and through AHPNJ to get that certification right now?
Yes, yeah, and that'll continue to be the case. I know I'm not aware of. I know that there are some, because the income certification is changing to HUD, and there are some certified HUD education programs out there. That may be another option for at least that part, the certification part of it. But you'll still have to go through some of the Rutgers classes as well.
Will there be a pause on the requirements for education when the guidelines have not yet been set? Great question.
Yeah, I think that we're not going to approve anybody unless they've been educated. So there's a pause, yes, in the approval. We're not going to, in the requirements, no, but in the actual approval,
Right.
yes.
Right. So, I mean, from a timing standpoint, and I don't know if I think if Mark was still on, who's very involved in the Rutgers program, in really trying to, it's going to take a little while to really synthesize all that information. You have the proposed, rules that, by the time those come out, Mark, when do you think that we could potentially get some updates to education?
That's a great question, but I feel like Keith and Heather are really driving the bus here. We're certainly willing to help out as much as we can, and I don't think I'm out of line to say that we have a big series of classes planned for the Governor's Conference on Housing and Economic Development, and they're all it's the current kind of focus of those classes in September, and it's going to be about 6.5 hours of total content, are going to be focused on the differences between old hack, and Heather, I love that you use that phrase, and new hack. And basically as like a little boot camp to help people get up to speed on various sort of topics of within UHAC. So that's in the works, and we've got preliminary approval from the organizers to run that track, and we've got panelists lined up, and so that's probably going to be the next most meaningful educational opportunity for the rule changes. And as I said, we're continuing to work as we can with DCA and Rutgers to kind of revamp the classes. But I just wanted to go back to that question for a second, though, and just make sure that, because I'm not sure I fully understood, Heather, your comment on that. So there are a whole host of people and organizations that have been approved that have gotten the affordable housing certificate from Rutgers. Is that certificate, can that be submitted now as a approval for an administrative agent, or is all these approvals on pause until the classes are revamped?
Mark, I don't know. I mean, so, yes, I mean, obviously that's a valid education, evidence, right? It's evidence of an education, but at this point, it's not correct anymore. So we're kind of caught in, that, I don't know if anybody remembers, but that really icky, 2004, 2005 time period when everything was up in the air and what are we doing and that kind of stuff. That's kind of this. So I think it's like a muddle through thing. Yes, if you have that, then you're just as, you can submit it, you can, it's hard to say that you're doing things right, because obviously if it's not even pertinent to the December version of UHAC, let alone what we don't even know we don't know yet. So we will accept it. I think what might happen is something like the governor's housing conference, or that may be a necessary next step. Even if you have your certification, we'll need to present those kinds of things for those folks that have been certified to get the newest iteration of UHAC into their conscience. So I mean, I look for more information from us as we roll this out. I promise we will be reaching out on those things.
So
I want to say that something is better than nothing, but as Heather just pointed out, some of the stuff is if the something is wrong, we kind of don't want to encourage that. And the timing on this is just kind of it's still so up in the air. HMFA has their interim rules adopted, but the final rules, I think that they've shared them with some folks in pursuit of their compliance with Executive Order 63, but I don't even know with whom those have been shared specifically. And I don't know if it's a special list of hand-selected people by them, or I don't know.
I've gotten them, and AHPNJ, some board members have gotten them, and we've collectively put some comments together and submitted them. So,
is there a deadline on those rules?
No, they're not publicly. It's not under a public comment period technically, but it will. The next step is to publish them in the state register and to have a robust public comment period and collect comments and all that sort of thing. So this is just sort of this interim step is, as Keith said, it's required under state law, but they just sort of handpicked a bunch of folks that were part of stakeholder meetings over the last year or so with them, and other pertinent groups, or like the Builders Association and other major organizations with a vested interest. I did want to go back really quick. Oh, finish, Keith. Go ahead.
Our comment period concludes on May 16th. The HMFAs hasn't even started yet, so we don't really know when and how long it's going to take to get all this stuff finalized, and you can't really put together a down and dirty kind of certification program until we have everything finalized. So it's going to be up in the air, and even by the time the governor's housing conference comes, who knows, we might be right up against things that have just recently become actually formally adopted. I don't know. It depends on how long it all takes and what kind of comments come in and what kind of responses are necessary. And it's going to
Keith,
be,
you want to unpack that a little bit? Because I think that's an interesting kind of topic. I mean, not just for housing nerds like me, but the idea that it may not take one iteration of public comment to finalize the rules, right?
yeah. Yep.
Yeah.
I
So
mean, there's
someone
always
could
the
make a comment
possibility,
that prompts a rewrite, and then that turns into another comment period, another draft that's put out, and this could rinse and repeat a couple of times.
yeah, that's a possibility. Let's hope not, though.
So
I just
I
want to
think,
quickly go back to
go ahead,
something that we talked about earlier about recertification, Heather. Certainly, income recertification is not part of our income process, our affordable housing process. It's probably the outlier of all affordable housing, right? I mean, the public housing authorities and vouchers and all sorts of other housing programs do have annual recertifications, but there are some things that administrative agents and MHLs should be doing to keep tabs on their units. And right on the rental side, new leases every year should be submitted by the landlord to the administrative agent, right? So we're confirming that the rent is still affordable and that the person's still living there. And then, of course, there's the annual mailing too. So it's not to say that once somebody moves into a unit,
Right,
whether it's owner or
exactly.
renter, that you're
Right.
just hands off. There is some continual data collection and information.
Yeah, just knowledge of who is living in the unit. But they do not have to be income qualified anymore after that initial certification.
a good clarification. So moving forward, are these rules in effect now? If not, when will they be? I think we just covered that. The May 16th comment period, but the discussion that we just had, who knows, right? There could be another session of comments. Okay. Is a developer allowed to have a unit moved to another site off of the development if they wish?
So that's not really an issue that's under our jurisdiction, these rules or UHAC. That's something that the Affordable Housing Dispute Resolution Program would either accept or not as part of the municipal submission for compliance certification.
Right. Next question, will there be training for MHL? I think we just talked a lot about that. And to point out, this series that AHPNJ is doing, and we'll continue to put forth, sessions and Q&As to bring people together to talk about this stuff. Because as we see, there's a lot to it. And hopefully we'll be able to get through some of this and have a better path forward. Okay, question. If an inclusionary housing project was approved in 2023 and is currently under construction, do I assume that any new UHAC rule would not apply, or do older approved projects need to comply with any of the new rules as they're adopted?
So for starters, that's a UHAC question, not a 5:99 question. But secondarily, I would suggest that pay careful attention to the wording in UHAC when you ultimately see it and see whether that issue is potentially addressed or not. It might be, it might not be, but it's one that needs to be looked at and incorporated into UHAC appropriately.
Yeah, I've heard this question recently. Another developer, under the third round, we have a project under the third round. How does that project then, move forward under which rules? And it is a very good question. I know hearing HMFA speak a couple weeks ago, any project under the third round would have to comply with anything that was under that third round. I don't know if, once these rules then, come into play for future monitoring, it'd be good to know. I don't have an answer to that.
Yeah, there's a section in the beginning of the December version of UHAC called applicability, and it's and basically it just describes where rules are applicable. And in the beginning of each subsection, there is it's supposed to be a discussion about the applicability of those rules on prior rounds. And one of the comments that AHPNJ made back to HMFA was to kind of improve some of that language in each subsection, so it's a little bit more clear, because I think that was an area of needed improvement. There were a couple of rather significant rule changes that that we thought needed a few more words on whether or not they were truly applicable to prior round projects or just fourth round projects. So hopefully in this next draft that we're going to see a little bit more robust language there.
We'll have some clarity. Thanks, Mark. Okay, will DCA be preparing templates for affirmative marketing plans, development fee ordinances, affordable housing ordinances?
Well, Heather is nodding her head, I see, but we hope to. But let me just point out the potential difficulty is that the review and approval of all of that is part of the task of the Affordable Housing Dispute Resolution Program. And we've got this thing called separation of powers with the executive and the judicial. We have been having conversations with the administrative office of the courts, and we've offered to make those types of templates available, not just to make the plan preparation process easier, but also to sort of standardize things, to try to help the Affordable Housing Dispute Resolution Program so that if they're looking at an affordable housing ordinance, they know what they look like because we've developed a standard. They know how to review it quickly and easily and what to check for. But we are waiting to hear back from them as to whether they want us to do that or not. I feel pretty confident that they're going to say yes, that they're willing to do that. And we'll probably be given permission to post stuff like that on our website. And with any luck, they will even have a link on their website that links to the documents that we prepare.
Again, though, given the uncertainty of UHAC, the Affordable Housing Ordinance obviously is very tied to UHAC. So that's not going to be available in any time that allows you to use it in your upcoming plans, probably.
Our main focus on this is the stuff that we have to be responsible for. So, we're looking to make sure that development fee ordinances and spending plans and things like that have some sort of standard format that can be followed and signed off on by the court. If they can't agree to what we're proposing as a template, then they're not going to be supportive of posting cross links between the websites. So that's still I feel pretty confident that they're going to go along with things, but who knows what happens at the last minute.
Yeah, it definitely is from a streamline, as a developer, trying to get anything that will help, facilitate what we have to do. So that's great, Keith. Question, when will CEU classes be available? I think we talked a lot about that already. It's a work in progress is the answer to that one.
But something like this is a continuing education, I would imagine. So things that are provided that, the different seminars and webinars and things like that AHPNJ does, all of that would be subject to being considered as CEU.
This class and the prior class that was also free, we did not set up CEUs for those two.
Okay, never mind. Forget I said anything.
But however, there are other sessions, and everything at the governor's conference is going to be CEU credit worthy. So to be able to knock out a year's worth of credits probably in one or 2 days.
Yeah, I think it's a balance, for AHPNJ, we know that this information is really critical, and we really want to get it out there. So this particular session we made free to folks, but we definitely will be having more sessions where you can get continuing education credits and other free sessions. Okay, here's an interesting question. There is an exemption in the local housing and redevelopment law for the low mod set-aside requirement. Does the new version of the FHA override that exemption?
I think that question should be directed to the legislature.
Yeah, I don't have an answer for that one either.
And in terms of what's included in the municipal plan, again, that's going to all depend on what the Affordable Housing Dispute Resolution Program approves as part of their compliance certification. But in terms of whether one law usurps another, we're not here to interpret the legislative intent. So
save that question for a different panel. Okay, so we have, since the new regs are not yet adopted, what is the time frame for submitting local affordable housing ordinances as part of the fair share plan? That's a great question. What do you guys think on that?
Well, that's already laid out in the statute. So the deadline for submitting the plans is June 30th. And then there's a period under which people can challenge the validity of the plan submitted by the municipality. That goes through August 31st.
Right.
And the administrative office of the courts, through their Affordable Housing Dispute Resolution Program, has until December 31st to settle any of those. So during that whole process, you know, the adopted ordinances are going to be part of that sort of moving process. So it's going to be somewhere in that time frame, and depending on what kind of challenges exist or not, you know, it might dovetail nicely with the time frames that we've got for getting standardized stuff out there, and it might not, but that's going to be a wait and see.
Here's a question for the MH. Does the MHL have to be an employee, or could it be a consultant?
It needs to be an employee, municipal
Does need to
employee.
be an employee.
There can be a shared, we're fine with like a shared services kind of arrangement where a couple or three or whatever towns can share an employee who does this. That is absolutely fine, but it should not be a consultant.
Okay. Run through these. If someone completed the AHP Rutgers program, but the certification doesn't arrive until June, would that person get the Rutgers cert and approved as an AA or MHL, or likely not?
Yeah, I mean, and if you have your certification, that's good. We
Right.
will need to update it once we have the new rules in place.
Okay. Will the expectations for the MHL be formally defined and communicated for those of us who are new to the role? There seems to be a lot of misinformation.
Well, the expectations are in 599. So that's what, you know, you need to do in order to, those are the responsibilities of the MHL. They're defined in there.
Okay. The definition of administrative agent is the entity responsible for the administration of affordable units in accordance with NJAC 599. Is it correct that administrative agent certificate applies to the entity, not the individual, which can receive a certification of completion described in the education section? Can the rules clarify how an entity can receive an administrative agent certificate?
Yeah.
Because
Thanks, Megan. Understood. Yes. So the rules are admittedly vague on some of that. I think that we're going to have to clarify that. It will be a policy. It won't be within the regulations. But yes, it will be. We will come up with the program and it will be clear.
Here's a great question. What was UHAC before and what is UHAC now? Heather, I think.
Sorry. Yeah, sorry. Yeah. And isn't it a lovely acronym there? Uniform Housing Affordability Controls. Is that what you're talking about?
Yeah, I guess when you say old UHAC and new
old hack
UHAC.
and new hack, that was Mark's thing. But
That's a separate webinar all on its own, and it's not ours.
It isn't ours, but it's tied very intrinsically to this whole process. So it is the regulations that outline how affordable housing units that are under the Mount Laurel provisions are administered. So separate from like something like HUD or home or whatever else might be out there, LIHTC, any of those things. That is how our units are administered. So it has been in place for 20 years since 2004. These updates are making changes to how we do things, and it's pretty foundational and fundamental to how these units are administered.
Yeah, it really is, and I have it here, printed, and I refer to it a lot. It really does govern a lot of how the affordable housing, functions, from marketing and income restrictions, to bedroom sizes. And it is, for the person that asked that question, when was the last time it was changed? 2004, Heather?
Yeah, that's the
Yeah.
most, there's been a few little updates here and there, tweaks and stuff like that, but not enough. So I think that the new rules are going to be addressing some of the antiquities involved with 2004.
Heather,
There's something that was out around this time called Understanding UHAP.
Yeah.
Yeah,
Will there be another one of those? Because that
Well-
was, I always found helpful.
well, I'm glad you raised that actually, because this is the weird relationship between DCA and HMFA. This has been an HMFA rule for the longest time, and it was COAH staff that took it upon itself to put together that book called Understanding UHAC, because we were more on the front, and HMFA is adopting these rules and
Right.
not answering the questions. So we had to do that.
Yeah,
So
that was very helpful over the years. So thankful. I'm very thankful for that. Okay, I know we have more questions to get through. These are great. If a project was approved by a township and the developer has their own AA, what are the steps to follow?
So that's going to be a town question, basically. So a town has to approve an AA. They have to say this AA is okay to use here. They'll probably want to see, at some point that is an approved DCA administrative agent, right? So that'll be one of those things that's kind of just expected. If you are going to administer a project in a town, the town is going to want to make sure that you are approved. Now, that's a process that we're going to have to put people through, and we will be doing that. But the first step would be that developer needs to have that conversation with the town to make the town aware that they have their own AA, and the town has to kind of bless that in some way.
Right, and so the next question sort of also, can a developer act as an AA for the placement in the units? And if so, do they have to share the information on tenants with the municipalities? That's a question that I have as a developer too. I know there are certain developers in the past through COAH were certified as AAs. I don't know, will you be able to do that going forward?
I would imagine anybody who does this work can be certified as an AA. Now, a town needs to make sure. I mean, ultimately, the town is responsible for the administration of their unit, so they need to make sure that they trust the AA and that there's a relationship there between the town and the administrative agent. So, I would imagine that developers can come forward and become approved as well as anybody else.
Okay.
I have a follow-up question on that, Heather. And I think this falls, or Keith, you might want to answer this too. Is there are communities out there that have their affordable housing portfolio, but don't retain an administrative agent on their own. They rely on developers to bring them to the table. Is it a best practice or a suggestion that a town have its own, even if it's not directly administering units, but have one available, kind of waiting in the wings? Do you have any thoughts or feedback on that?
Potentially, I think that is a good idea. I don't know if a town can tell somebody who they have to contract with, but it does, like, think about just the experience of the applicants. It does make it easier if you've got 1 or 2 AAs in your town as opposed to 10. That's 10 different applications. So, from that perspective, I think that it's always better to have fewer AAs. But again, I'm not sure that a town can mandate that. That question, I don't know.
No, I wasn't really thinking about mandating necessarily, but I was thinking, like, if you have, and I was really following up on that comment that you said, that it's ultimately the town's responsibility to make sure that the units are creditworthy and adhere to the regs. If a developer is serving that role as administrative agent, would it be helpful for a town to have its own administrative agents just to be available to, like, oversee, just to double check things and
Potentially, yes.
yeah.
I've done that before, and the town just feels better. And I would imagine that the town would mandate in the approval process any kind of connection between their own AA and the town's AA. That that may need to become a part of your affordable housing ordinance in order to mandate that for an approval of a development, with affordable units in it.
And so the MHL is ultimately responsible for overseeing some of those administrative agent functions. So it would, I think a best practice would be for MHLs to take some of the additional classes beyond what's minimally necessary to be an MHL, so they can understand more of the roles and responsibilities of AAs. But going to another scenario, Mark, would be where the developer, it's a rental and they've built it and they're done, and 10 years later they decide they want to bang out of it and they're selling it to somebody else. You don't know who the new AA is going to be in that case. And so I think that it would be in the municipality's best interest to always be thinking about the possible need for a backup plan.
DCA requires housing rehabilitation assistance loans under some of its programs be in the form of a repayable loan. Will housing rehabilitation loans made to meet present need under UHAC include a requirement that loans be repayable?
No, UHAC doesn't go into rehab at all. So no, and those decisions, as far as I know, they've always been the municipal, a municipal decision. I can't imagine that the program would have anything different to say about that. So
I'd love to hear comments though, just stepping away from this supposed rule, the idea of making a loan repayable for rehabilitation, a low and moderate income person in the community making a rehab loan repayable, I feel like I mean, of course, a deferred loan could work too, where the rehab amount is repaid on title transfer. But I mean, that could be 20, 30, 40, 50 years from the original investment in the property. And the idea of making monthly payments or any sort of like monetary payments on a regular basis, I would strongly caution anybody from trying to set up the infrastructure to do such a thing. It is far more difficult than it sounds, and it has not ended well in most of the situations I've seen along those lines. I don't know if Keith or Heather, if you have any comments on that.
I mean, it's typically been a gradually decreasing forgivable loan, so.
So for every year
I'm not
there,
sure.
Like the value, the principal of the loan would burn off until you reached a point where it was zero, like maybe 10 years out.
Yeah, I don't know which programs are requiring a repayment. Small cities. I'm trying to think Steve, let me know which ones you're talking about, and I can see if I can find out about that.
Home, I think maybe home.
Oh, that's not oh yeah,
DCA.
through DCA, but potentially, I don't know.
Okay, is the spending plan required to be submitted with the fair share plan, even if there is no template? Can we use a third round template for round 4?
Oh, yeah.
I would recommend that.
Yeah.
As much as you can, yes. I
I
mean,
mean, the program is going to require a spending plan. There's no question about that, and
it's what everybody's used to seeing.
Yeah, and candidly, what we develop as a template for a 4th round spending plan is not likely to be significantly different than what we developed in the 3rd round, because everybody seems to support that format and they think that it works well. So again, if it's not broken, we're not going to try to fix it.
I see a couple more questions about AAs popping up. Can an owner developer contract with their own A versus the town? Can a municipality be its own AA?
Yes.
How would the town oversee a developer's AA? Are there specific items the town should get?
they should get. I don't know, potentially, if you wanted to see the waiting list, if you wanted your AA to have a copy of the waiting list so that you could guarantee that the people who are being put into the units are coming off of that waiting list. I mean, I guess it depends on how much you you know, trust the administrative agent that the developer is using. Again, the municipality is responsible for the administration of their units. And so I think that it could go to, you know, the lengths that it needs to ensure that the units are being done properly.
And it kind of goes back to Keith's point about the municipal housing liaison, you know, trying to, you're getting this stuff together, ensuring that, you know, this AA, because it sounds like it's a very important topic to a lot of folks. You know, who's the AA? How is it done? So I think as we start to see more information come in, maybe classes or seminars on that.
Yep.
Because there's a lot of questions about that.
Yep.
Okay. Is there any mention in the regulations about a universal system for application and certification process?
No, not that universal. I mean, I'm guessing that one point of entry for all applications. I mean, we tried that and there were thousands and thousands of applications across the state. So that just, it's cumbersome. Unfortunately, it does not work in any way that we could tell. So no.
I think that as we, you know, technology, you know, we are starting to see the ability for folks to apply online, making it easier for folks to get into the lottery, that, you know, when projects are built and units come online. I know that the state has been trying to streamline, you know, get the Housing Resource Center website to be more user-friendly, and really forcing, you know, developers and folks to list those opportunities on that website. But I know right now there is no one system for that.
We've had a couple of conversations with our Division of Housing and Community Resources to see if there's some sort of high-tech something or other that might be able to be developed, not just for these units, but some, you know, the other units that are part of other programs run by DCA. And everybody just recognizes the challenge with being able to do that, because, you know, you've got, in some cases, we have regional numbers that have to be addressed. We have affirmative marketing that has to be to a specific region that's multiple counties, and other programs don't have that. But it's not to say, though, that, you know, as technology advances,
Sure.
and, you know, we might be able to come up with something. I mean, we would love to be able to. It's just a matter of working through the logistics of it.
Yeah.
Well, if my daughter can get chatbot to do her homework, I don't know. Well,
Ask her if she could develop a system for us.
Okay, let's run through. I think we're over our time, but we want to definitely answer everybody's questions. Let's see. Will the new rules have specific steps laid out and list numerous required documents that an owner must provide when an owned unit is being rented out by the owner to resolve the problem? Does the MHL get involved, or is it strictly handled by the AA? Does the owner have to sell? It's a
yeah, I guess so. This is talking about more of an enforcement kind of issue where the owner must provide when an owned unit is being rented out. So units must be lived in by the owners of record, who was the person who was certified. So that, I mean, it starts out as an AA problem, right? Generally, the administrative agent will become aware of the situation, and they have enforcement powers to, you know, force the owner to move back in or to sell the unit. It potentially becomes a municipal problem if the municipal attorney needs to get involved in something like that. Hopefully it doesn't escalate to that point, but yeah, the MHL would get involved. An AA needs to have a good relationship with the MHL in their town so that they can call them and say, hey, this is going on. You know, I just want to make you aware. stuff gets around, mayors get called, you want your MHL to be aware of things like that that are happening. If you're enforcing something, it's a good idea to touch base with your MHL. If you're sending out an enforcement letter, maybe copy the MHL on that letter, that kind of thing. Just to make them aware. That should be a good symbiotic relationship there. So, and I would encourage you to keep that going. Does the owner have to sell? They don't have to, but they have to move back in if they don't. So it has to be lived in 260 days out of the year by the owner of record. So
I think I skipped one. Okay, does the spending plan have to be submitted into the AHMS system?
we will need to see spending plans. And I'm going to encourage the spending. There is a section in AHPNJ for spending plans. So we're going to encourage people to put their information in there because it's going to be able to be checked against your expenditures and revenue section to see how you're doing, if you're meeting your requirements, your affordability assistance, those kinds of things. So so yes, I would say yes. There's also a place where at the end where you can upload documents. I would encourage municipalities to put as much as they can in there. We have different folders that you can put things into. It helps us to have access without going to dockets to your plan, to your affordable housing ordinance, to your spending plan, those kinds of things. So it doesn't, it's not a requirement, but it's a tool that's available to you and helps us to monitor your spending as well.
So what we will have to do there though is, we don't know who's uploading information into AHPNJ with regard to spending plans, or more importantly, I guess, is, when they've uploaded it. And unless and until it's the final version that's been blessed by the Affordable Housing Dispute Resolution Program through the actual issuance of a compliance certification, we won't be able to know for sure that that is the spending plan that was approved. So we are going to have to do some cross-checking with the documents that are filed with the courts and what the court is publishing through what they're calling their civil, whatever it is, civil courts case jacket. We were hoping to be able to develop a bi-directional communication system with the courts so that we could share documents back and forth, but that has become a challenge.
And also if you come to us with any kind of emergent opportunity, we will definitely need a copy of your spending plan.
Yes.
I think we have answered this one. Has a fourth round spending plan template been released? I think the answer was no, right?
Not yet.
Not yet.
So use the third round, I guess, as a template. Did I ask and answer all the questions? Oh, here, can you discuss what information will be public versus the information in AHMS?
Right. So I'm guessing that's about the database that has to be published.
Right.
Keith, do you want to take that?
We're going to do our best to publish everything. And so we've got multiple reporting requirements. There's the Affordable Housing Trust Funds, of course. So, we'll be showing collections and expenditures and some categorization of the expenditures so that it'll be publicly available data to be able to see things like percentage spent on admin and, that kind of stuff. And the nature of the expenditures with regard to the affordable housing delivery mechanisms on the project and unit. That's going to be, again, we're going to try to cover everything that was required by the legislature. So it's going to be the distinction between owner occupied and rental, age restricted, special needs, the date that the unit went into service and the length of controls, and basically everything that's in that law is going to be what we're going to put out there publicly. And, just to reiterate what I said earlier, a lot of municipalities were continuing to use the CTM system even after the courts took things over from COAH. And we did migrate all that information into AHPNJ So to the extent that municipalities did all that work, they are way ahead of the game. But even then, some of the way that that information was reported may not have had sufficient detail to comply with all of the painstakingly brutal details that are required as part of the legislation. So I'm going to venture to guess that once we report some of the stuff, and hopefully we'll get some reporting out within the next few weeks on the February 15, 2025 deadlines, I think you're going to see a lot of things where you're going to look at it and say, well, wait, that doesn't make sense. That doesn't seem right, and probably some of it won't, and we're just going to have to strive towards doing better in 2026.
The information though is going to be consolidated, so it won't. I don't think it's going to include addresses or anything like that. So it's numbers, not addresses. So no worries on providing things that don't need to be out there in the public.
Yes, no PII. It's all just aggregated to the municipal level.
Okay. There were two more questions. One, will municipalities be required to monitor present need obligations in the unit monitoring?
That's what it's all about. Yeah.
Yeah.
Yes.
Yeah. So your rehab units, present need obligation. Yes, that's still in there. It's, address, how much did you spend, that kind of thing. That's all still in there. So yes.
And then the legislation says monitoring is required for units actually constructed. Do planned projects need to be entered?
No.
Yeah, I wouldn't think that would be.
They don't have to be, but it is a tool. So if you want to have everything in there, then absolutely go ahead. And I mean, if it helps you to track the things that are in your plan, then absolutely use it that way.
Yeah, for those of you who haven't used AHPNJ yet, there's each project is something that has to be entered, and then there's the detail on the individual units within that project. So once the project itself is actually approved by the Affordable Housing Dispute Resolution Program, you don't have to do it this way, but my recommendation would be to start entering all that information into the system so that you have a holding place to put the units as you start getting information on completions, whether it's from your construction code official or from your administrative agent or however you're working out that information. But it's so much easier to report things a little bit at a time as they're happening, as opposed to waiting for a whole slew of things to have happened, and then you got to go back and backfill everything.
Sure. Is there training on AHPNJ, like just say maybe like the League of Municipalities? Would there be like a session they could do? I mean, I'm not familiar with this, program.
With the system, we did do several training sessions, webinars back when it was released. So if you go to our website, you can see those webinars, and people can always call or email us. We're here to help. We're here to provide guidance on getting that information into the system.
Yeah, and I think that's, I think I answered all the questions. But I do think that that's the key takeaway here is that there's so many folks and so many divisions working on this. And it's groundbreaking changes for New Jersey. And, I think I was telling Heather this when I spoke to you, we're all a part of this, we're making history here. And it's going to take a while for everybody to really get up to speed and get these rules adopted and updated. And it is a work in progress. And the more folks, review it, read it, comment on it, and then work with it, because it's really the frontline folks at the end of the day, are the professionals, the administrative agents, the municipal housing liaisons, the management agents, who really have to, work with all of this. And, it really helps to have a good handle on knowing how to do it. So with that, I would like to thank Heather and Keith for spending your last hour and a half with us. And if folks have any other questions, definitely reach out to us. And remember those deadlines, please, for making comments and getting things in So I think that's it. Mark, thank you. Brian Rappaport and the whole AHPNJ board, and Lindsay, this has been a great session.
Thank you all.
Thank you for having us.